Doctor, what word? Doctor na Google. Special vigilance. 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 Yeah. But I don't know. I said. Yes.
Made clear. Lordship, in earlier occasion, Lordship, for non-recording of the 164 statement, my bail was rejected. This is a second bail application of the accused.
For non-recording.
Yes, Lordship. At that stage, Lordship, the 164 statement of the victim was not recorded.
And which
Okay.
page? The order of rejection?
Rejection page 20, operative part, it starts from page 18. May I read? After hearing the submissions made by the learned counsel for both the sides, I have perused the case record and case diary, as well as statement of the victim recorded under 164. It is seen that the probability of tampering with the evidence of the witnesses as well as the material witnesses, specifically the victim, cannot be denied at this stage. Hence, I do not find fit case to enlarge the accused petitioner on bail at this stage without recording the evidence of the
No,
victim.
that is from 164. That is the evidence
yes,
of the
yes.
witness.
Yes.
Anyway, now at this stage, what is the position? As per
Yes, yesterday it was fixed on 9/6. They did not turn up, Lordship. This is the order.
9/6 for evidence.
last one.
Last one.
As per
But
last.
it is, yes, but it is not there. Right? It is yesterday.
Yesterday, we have yesterday.
Yeah, only charge framing order is there. Right?
My next
So you
ground.
have received this one, whether we call for anything last occasion, no. Or due to some personal inconvenience, it was not taken up, I think, na?
Yes.
Now, Lordship,
No, but the question is that the case is today is fixed for bail hearing, in fact.
Yes. It is
So why in hearing call?
Bail here.
Call record is already received.
Yes, LCR also is received.
Is received. Okay.
But it is since the date is of 9, yesterday's date, that is not reflected as my learned friend.
yes, yesterday, therefore.
Is not. Charge framing order, I have flag mark. You'll also may kindly see the last.
Lordship, my second ground is that the grounds of arrest was in the notice also, it was not given.
Anyway, once it was rejected, so we have to just, as per your information, 9/6 is, the case is fixed on 9/6.
9/6.
Yes, what do you say, on to say, Goswami, in that regard?
Well, yes, my one date gone, I have no idea on that what had happened, but it is fixed for evidence after the framing of charges, and the victim statement has to be recorded. At least the statement of the victim has to be recorded, at this stage,
Next date is 16/7. Therefore, what I wanted to point out, Lordship, in the notice under 47 also during arrest, Lordship, this is the notice.
Yes, we have already have next one.
You are hereby informed that you are arrested in connection with the above reference case and the case is non-available to police. So you are forwarded to Honorable Court. Therefore, Lordship, no grounds is there. Now, your Lordship's judgment is there. A complete judgment referring all the Supreme Court judgments, wherein non-communication of the grounds in notice has been held, that the arrest has been held to be illegal. In arrest is 295 days already in custody.
Anyway, if you got anything you want to submit, Goswami?
I'm just going forward.
Okay, then have you also annexed the arrest memo here?
No, not the arrest memo, just the notice Notice
The
under
only notice you
47.
have annexed.
Yes.
Arrest memo is with you? No.
No,
Arrest memo
no, Lordship.
or 48 arrest memo?
No, Lordship.
It
I
may
think
be
it
available
is
in the
not
case
informed.
record.
It is in violation of 47 also, because in 47, the basic facts has to be there, Lord.
No, whatever, 48 or, I mean,
40
arrest memo, is there any clarification?
Arrest memo, I don't have to.
You have, Gusam, you can go through the arrest memo.
Arrest memo.
No, yes, madam. Regarding this, another aspect is also in item number 5, madam.
Item number 5?
Yes, it will be after some in item number 5, there is the same ground has been also taken regarding the grounds of arrest, madam. Regarding only my learned friend will submit in the same way, my lord. So I will not my lord, take much time on this regarding the arrest part, my lord. I am only my lord. Lordship may kindly take it, my lord, together. my
Along
lord.
with item 5.
5, my lord, then not together, my lord. My argument will be same regarding that, regarding the grounds of
That-
arrest, my yes, but and my lord, only the material part, my lord, it's a minor, since it's a minor, my lord. But
Minor age, what is our age?
age is my lord,
Now-
but interestingly, my lord, as per the search order, my lord, it has been hold that she is a minor, my lord. But the charge was, my lord, on 376 to N.
376 too?
What is that?
762 N, but the case was registered under POXO, my lord.
No, initially it was registered under POXO, but in the search sheet, yeah, because as per the school certificate, it was held that she was not a minor. Therefore,
But the charge,
Subsequently charged it was.
some search was not fair.
but the charge framing order is, my lord, I have seen, my lord. There, my lord, it has been, my lord, hold by the honorable court, my lord. That apparently.
Charge framing order is there in
Yes, my
this
lord.
record.
It is in the record, my lord, so we kindly peruse, my lord. If that is the case, then notice has to go, even to the victim, my lord. Even otherwise.
Otherwise also notice that
Otherwise also notice has to go, since the victim has to be heard in every stage. my lord. But it is not a made party there, my lord, in the petition. my lord.
you have not made party.
Not made party.
No, Lordship, because she was not a minor, Lordship. And
But.
only 376 to N offense under.
As per notification is 376 there is included, I think,
It is
or
not,
it's
but
not,
the,
only
as per the
POXO.
judgment, as only POXO is included, but as per the judgment, my lord, that victims has to be heard. my lord.
Lordship, what I am not on the technicality part. What I want to urge is the point of law, Lordship, what the apex court has said, that if I can show that notice, no communication of grounds was not there, then
Okay, we'll hear the
14,
matter.
even for a
Mr.
second, they cannot.
Locker will submit.
Yes. But that is also to say part, that has also been decided that victim has to be heard before giving any. We cannot bypass that also.
No, in our notification wherein we are passing the order of the notice. But from you're
But-
saying on this
But as per the
Judgment.
Yes, Mr. Judgment, my lord, that in any stage of proceeding, a victim has to be heard. That is the mandate of the law.
okay, we'll submit it.
Yeah. And apart, my lord, 164, your lordship may favors, my lord, that is very much implicating, my lord, because by threat, says by inducing threat, my lord, the victim was raped 50 times by blackmailing and by resorting to such type of in
But while
Three times.
inducement, my lord.
place the statement, Lordship, it is there. Even in page 26, Lordship would find in the order, charge was framed only under 376 to N. Lordship is taking this matter along with 5. No?
No, yours only, that part only hard. Otherwise, you have any submission, you can make your submission. We are not going to hear twice that matter.
Oh.
A matter cannot be heard twice only on that issue, that may be, but otherwise,
Yes, Lordship.
taking the, after sitting a whole day for division bench, again
That-
sitting
that is-
special bench, I am not
that-
taking
that
anything.
That is,
The same submission, that is why I'm not making
Hmm.
just only one.
Only that, in that regard only we are going to hear. Otherwise, if any submission is left, you can make your submission.
Lordship,
You can make.
the medical report is also in my favor. Moreover, Lordship, it was fixed for evidence and they have not turned up. Therefore, Lordship will consider already 295 days have gone, Lordship. Therefore, on the
295 days.
295 days. Therefore, on the part of length of detention also, Lordship, on only on merits on that part, Lordship, only on the length of detention, because as per the last order of your Lordship, the evidence is also not been taken. Therefore, I will only urge on the length of detention on merits. Otherwise, on the ground of non communication of grounds, as per the notice also, Lordship, Lordship will peruse the arrest memo also. If the grounds of arrest is not communicated, Lordship, as per para 14 and as per your Lordship judgment in Gori, Lordship, in Gori Kumari, Lordship has every judgment Lordship has referred and come to a finding that even in cases of special acts, this non-communication of grounds is fatal and arrest is illegal, Lordship. As per Lordship, Article 21, it says that detention is under the Constitution is an exception, and for a deprivation of personal liberty, Lordship, procedure established by law has to be followed, and the procedure established by law is that before arrest, the grounds has to be communicated. So therefore, Lordship, this arrest is not only violative of Article 21 and 22, but also violative of 47 and 48 of the BNSS. Therefore, it is violative of the Constitution and it is violative of
They
the
don't make
statutory laws.
further submission, we'll hear the matter on,
Yes.
while hearing the matter on item number 5. Otherwise, rest submission I have already recorded.
My investigation matter, it may not be taken into account because if a lordship finds the matter case and the gravity of the offense and the statement and conduct of the accused minor, there's every sense of minor hampering and tampering with the minor victim minor, because victim, very important part of victim statement yet to be recorded.
Lordship, that tempering part can be dealt with putting stringent conditions, Lordship.
It's Tarahunti.
LCR.
LCR.
Order, charge and every that one.
2 and 3.
Two and three, we have received the case record here.
Yes. So was the registry.
Now we have received.
In this case, I mean, we are on behalf of the prosecutor, madam,
On behalf of the prosecution.
we are a special public prosecutor. And we intend to file one objection, madam, more this, after verifying the records. ma'am.
Yes, Bora, anything to say? They want to file an objection.
Tomorrow, it's tomorrow.
Now that is the another problem. Tomorrow, how many matters we have already fixed? Tomorrow, 3 matters have already been fixed by us. Because what I'm facing the shortage of, in fact, because whole day sitting there and again coming. But anyway, tomorrow 3 matters are already been fixed. Some others will come as a supplementary. So now on Friday, Friday there are 2 matters still now. That may be one of the,
Yes.
if you filed on Friday. Otherwise, record is with us.
I understand.
If
They
anything,
could have filed it long before. They have taken time at their own request, my lord. This case is fixed today. I have
yes, that I can.
that because of the learned, he has submitted that today it will be hard. And today at this stage, my lord, They are now saying that they want to file an
So
objection.
one day or 2 days will not make any difference.
No, makes a difference, my lord, for me, my lord. It may not make a difference for him because they are not in custody, my lord. I am in custody, my lord, and they have taken a time, my lord, on last occasion that this date is, they have taken a fixed date. This, the learned public prosecutor, he has fixed the date for today. And at this moment, they are coming with a plea that they want to file an objection. What they are doing for last 10, 15 days, my lord, when the last
Yes,
matter was came
last,
up.
it was listed on 2/6.
2/6, my lord, and today is, my lord, 11, my lord. And I have prayed, my lord, the short date. On their plea, my lord, it was fixed today.
I can remember this one.
At their instance, my lord. I have not objected on that day, my lord. They have fixed it now. They have come up with a new plea that they want to fix it. They could have filed it, my lord, long before. This is just a delaying tactics, my lord, nothing more than that, my lord.
One day, well, will not make a difference, madam.
One day it is not possible for the court to tomorrow. It's
Tomorrow may not be possible. That's why I'm just looking for how many cases are fixed. So Friday, just Friday you do it because definitely case was fixed, the urge of Mr. Doctor, isn't it?
Yes, yes.
So you said that on that day. So according to you, we have fixed it on 11th. Obviously, by perusing the our list also that is there.
No, that is
Fine.
their case, my lord. The solicitor, they want to go to the record now, my lord. It is their case. They have appeared in the trial court and they want to go to the record now. This kind of submission, my lord, at the High Court level does not suit, my lord. I'll leave it to your lordship, my lord. They want to go to.
Had Mr. A.M. Bora, the learned senior advocate, assisted by Mr. V.H. Chaudhary, V.H. Chaudhary, the learned counsel for the petitions. Duta petition আছে, হ্যাঁ? একে same order. And also heard Mr. P. Kotoki. Your name will be written now, Special Public Prosecutor. Now, otherwise we have in the Special Public Prosecutor is vigilance was there, na?
Vigilance ethical. CM vigilance.
CM Vigilance, Special Public Prosecutor, CM Vigilance. Assisted by Mr. B.P. Doctor, BP Doctor, same, learned Special Public Prosecutor. At a request made by Mr. Kotoki, released the matter accordingly on 13/6/2025, asking the state respondent side to file the written objection, if any, on or before the next date of listing. The matter may be list or before. So if you can, if somehow if it is not possible also on our part, the record is with you, with us, so we can peruse. At best we have, because tomorrow will not be possible, that's why I'm fixing it on 13.
Yeah.
Okay, Mr. Bora, we
Yes.
start.
Keep your face.
Item 5.
It came.
Yes.
এটা fix 6 4 years old. মেসেজ ফিক্স করে নিয়ে দেবো 2টা 3টা বাকি আপনি আমারটা মেসেজটা কনভে করে দিব because problem তো হয়ে যায় না and somehow it was ended by 340 or 345 after tomorrow may not be that the position may not be there also আমার কাৰণে আৰু কেছবিলাক দেখা বহুত ভাল নালাগে আহিছিল অৱশ্যে কালি তেওঁ ওচৰত কৈছিলে আমি প্ৰব্লেম মানে ফেচ কৰিছে যিবিলাক আৰ্লিয়াৰ ৰিজেকশ্যন বা আৰ্লিয়াৰ হেৰি those matters will be fixed whatever item 4 na
5.
item 5
5.
4 is where 4
4 is probably 80.
This is for big hearing.
oh church okay then 5 na
Five.
oh
The Lordship may kindly peruse the last order passed by your Lordship. That 6/6/2025.
yes
My submissions were recorded on that day.
yes
I have made 2 folded submissions. First was that he was not produced before the concerned magistrate within 24 hours. And second was non-furnishing grounds of arrest at the time.
yes
So in support of that, Lordship, I have also submitted one bail.
they were as per your submission they were arrested on 25 2 but produced on 28 2
28
and apart from that
grounds of arrest.
grounds of
So
arrest
for-
was taken
That on the other day, I have shown it to your Lordship from the arrest memo and forwarding report. One thing I missed, just I am pointing out that also.
huh
In the charge sheet also, Lordship will find the same thing, page 21.
page 21
Yes.
That is the charge sheet.
in the charge sheet. They have mentioned the date of arrest in bold, that is 25/2/2023,
Hmm.
page 21. Then forwarding, your lordship will find date on which forwarded 28/2/2023. Top portion Shaidur Rahman, his name,
Hmm.
that serial number 16 and 18
Hmm.
in Roman,
Hmm.
16 and 18.
Hmm.
So it is admitted fact that he was arrested on 25 and forwarded on 20.
Hmm.
That is not within 24 hours. And in support of my submission, I have given on coordinate bench judgment on the other day, if it is available. in the
Coordinate
record.
bench judgment?
Yes. Bittu Kumar,
Let me see. One coordinate bench is here.
Bittu Kumar,
Bittu Kumar?
yes,
Yes.
that is there. So in that case, paragraph 6,
So you want to show from the charge sheet also that the date of arrest was on 25
yes,
and the production was on 28.
20. And the notices I have already placed before your lordship. Notices your lordship will find from page 97 onwards, typed copy as well as certified copies. 98 is the notice under section 50 CRPC. No grounds mentioned.
Hmm.
Then arrest memo, your lordship will find page 99 typed copy, certified copy, page 100. And all these documents were placed before the concerned magistrate on 28/2/2023, along with the accused person.
Okay.
That is my son.
Yes, Locker, you were supposed to submit here.
Wherein this is also. Is arrest is
Basically, 2-3 counts is Mr. Ahmed has taken. Number one is he was arrested on 25/2, admittedly, on 23, and then produced on 28/2. That is one ground. That is after 3 days he was produced before the learning magistrate. And it showed from the charge sheet also same here that forwarded on so and so. Apart from that, those grounds were taken. Okay. Yes.
Lordship, here in this case, Lordship, he was arrested on 25/2/23.
Yes.
And the main issue is, Lordship, whether Article 22(1) is complied with or not, Lordship. We'll come to the second part also later on, why he was not produced before the magistrate on that day or within 24 hours. That I have taken mark it on already. So, Lordship, on 25/2/23, he was arrested. And as per the mandate of Article 22(1), he has to be informed the ground of his arrest. And the issue has come prior to the Pankaj Bansal case, Lordship. In Pankaj Bansal case, judgment came on, Lordship, 3/10/23. When Pankaj Bansal judgment came, Lordship. And his arrest is prior to Pankaj Bansal, Lordship. Why I am pointing out the Pankaj Bansal judgment, Lordship? Because, Lordship, prior to that, Lordship, there was no any stringent anybody written, Lordship, that Lordship written ground of arrest has to be given. It is only after Pankaj Bansal case, wherein it has been opined that ground of arrest has a written ground of arrest should be furnished to the accused person when he was arrested. So, and in that judgment, Lordship, I have already given the citations, Lordship. Lordship may kindly peruse, Lordship, Pankaj Bansal judgment, Lordship. It is para 35, Lordship. Gutikita judgment video. Gutikita video. Para 35, Lordship, last phase. On the above analysis, Lordship, go to this. On the above analysis, to give true meaning and purpose to the constitutional and the statutory mandate of Article 19(1) of the Act of 2002 of informing the arrested person of the ground of arrest, we hold that it would be necessary henceforth that a copy of such written ground of arrest is furnished to the arrested person as a matter of course and without exception. So Pankaj Bansal judgment says that henceforth. So when henceforth says lordship, it is lordship prospective lordship. It has been defined that the written ground of arrest has to be furnished to the arrested person. That is the prospective issue lordship. That prior to that lordship, there is no any written lordship. The ground of arrest has to be in written. I will come to the later on. I will come to the judgments of 1966 AI lordship when it is the lordship. He has to be told. That is also the lordship. Most of the husband he has to be informed. He has to be told like this. No, where is the lordship that written ground of arrest has to be furnished. So after Pankaj Bansal. So prior to the Pankaj Bansal judgment lordship, he has been arrested lordship. Thereafter lordship, the second judgment came lordship on the same issue lordship. Ramkishore Arora. All these are two judges bench lordship. Ramkishore Arora came lordship. In Ramkishore Arora lordship, will find in para 23 last page lordship. Wherein the Pankaj Bansal judgment has been confirmed and some observation has also come lordship. And then lordship will from the very beginning 23 as discernible from the judgment in Pankaj Bansal case, also noticing the inconsistent practice being followed by the officers arresting the persons under section 19 of PMLA, directed to furnish the ground of arrest in writing as a matter of course, henceforth meaning thereby from the date of the pronouncement of the judgment. The very use of the word henceforth implied that the said requirement of furnishing the ground of arrest in writing to the arrested person as soon as after his arrest was not the mandatory or obligatory till the date of the said judgment. So these judgments says lordship, the same constitution bench lordship, judges bench lordship, that this was not the obligatory. Thereafter, lordship may kindly come to the can skip 4 lines lordship. Thereafter, lordship will find that hence non-furnishing. After 4 lines, hence non-furnishing of ground of arrest in writing till the date of pronouncement of judgment in Pankaj Bansal case could neither be held to be illegal nor the action of the concerned officer in not furnishing the same in writing could be faulted with. So what the lordship, it is said lordship, if you prior to that lordship there is no any ground of arrest has been furnished, then also lordship it is not a faulted with lordship. So lordship, thereafter lordship, yes lordship, thereafter Pravir Purkast came. In Pravir Purkast some guidelines has been framed that how it is to be how those ground of arrest. After Pankaj Bansal lordship, it is states the on this word is the retained ground of arrest has to be furnished. So if someone is giving, even though if someone is giving in the form of section 50 notice, then also it is applicable because lordship, though there is no the word ground of arrest is not mentioned, but it has been given to them lordship as a section 50 notice. Section 50 itself says it is a ground of arrest. But after Pankaj Bansal, R.K. Arora came lordship after. Thereafter Pravir Purkast, in Pravir Purkast case lordship, it is stated lordship. There's some guidelines are there that the ground of arrest has to be in such manner, in such region of arrest has to be manner. So we can think lordship that after Pravir Purkast we have to give some reason why he has been arrested lordship. So thereafter lordship Bihan Kumar came in Pravir Purkast. Yes, in Pravir Purkast also lordship it is the ratio has been taken from the Pankaj Bansal judgment. In para 51. Para 51 lordship will find it lordship, the last page. As a result, the applicant is entitled to a direction for release from custody by applying the ratio of the judgment rendered by this court in the case of Pankaj Bansal Supra. So ratio has been taken from the Pankaj Bansal judgment lordship. So ratio has been taken from Pankaj Bansal judgment. Even lordship will find one more paragraph wherein the Pankaj Bansal henceforth that has also been accepted. Para 45. Para 40, Lordship will find Lordship. It was the fervent contention of learned ASG that the case of Ramkishore Arora Supra, a two judges bench of the court,
Yes.
A two judges bench of this court interpreted the judgment in the case of Pankaj Bansal Chopra to be having a prospective effect, and thus the ratio of Pankaj Bansal Chopra cannot come to the appellant's aid. Indisputably, the appellant herein was remanded to the police custody on 4th October 2023. He was remanded 1 day after Pankaj Bansal lawsuit. Wherein the
Pankaj
judgment
Bansal was on 310, or?
10 lawsuit. Wherein the contextual submission of the submission regarding the late uploading of the judgment, learned AJ cannot be permitted to argue that the ratio of Pankaj Bansal would not apply to the present case. Hence, the plea of Sri Raju AJ, learned AJ, that judgment of Pankaj Bansal would not apply to the proceedings of the remanded made in 4th October. So, Rosie, here it is also opined that as he is arrested after Pankaj Bansal, then Pankaj Bansal's ratio has to be applied. So, this has been also come, the ratio has been taken from Pankaj Bansal. Thereafter, also Bihan Kumar came, Rosie. In Bihan Kumar also, Rosie will find in paragraph 15, Rosie, that Pankaj Bansal, the ratio has been taken. The ratio of Pankaj Bansal has been, ratio has been taken from the Pankaj Bansal case. There is para 15, Rosie. We have
Yes.
We have already referred to what is held in paragraph 42 and 43 of the decision of the case of the Pankaj Bansal. This court has suggested that the proper and ideal course of communicating the ground of arrest is to provide ground of arrest in writing. Obviously, before the police officer communicates the ground of arrest, the ground of arrest have to be formulated. Therefore, there is no harm if the ground of arrest are communicated in writing. Although there is no requirement to communicate the ground of arrest in writing, what is the requirement of what is the stated in paragraph 42 and 43 of the decision of the Pankaj Bansal? The Pankaj Bansal in as per here, Bihan Kumar has also opined that Pankaj Bansal judgment is a suggestive only regarding giving ground of arrest. Thereafter, some guidelines in Bihan Kumar, some guidelines came, which is something more than the Probir Purkaster. In Probir Purkaster stated, Lordship, if you go back, then Pankaj Bansal says written ground of arrest has to be given. Thereafter, Lordship, in Probir Purkaster says, Lordship, ground of arrest and region of arrest differentiated. So ground of arrest has to be in proper way. So some more clarification. Thereafter, Bihan Kumar came, some more another more clarification that even the language which the accused know, that has to be written. We have to communicate in that language. That is also. So, Lordship, these are the Lordship. The main thing is Lordship, the informing the ground of arrest. Subsequently, that is the developing. All these are developed one by one. So, Lordship, if we comply the judgment of the Pankaj Bansal, giving some ground of arrest to the accused person, as it is nowhere mentioned how it is to be formulated, how it is to be written, and they claim after Probir Purkaster that is not as per Probir Purkaster, it is gone, and he is allowed to go on bail. Thereafter, then again we are complying with the requirement of Probir Purkaster. Then after coming Bihan Kumar, they are saying, though it is Probir Purkaster, but it is not as the accused do not know the language, English language. So he is to be released on bail. So we cannot go by the judgments of each and every aspect, Lordship. Sometimes, and the main thing, the ground of arrest is that is to be there is a furnished, Lordship. And there are some persons wherein the NDPS cases, Lordship, people caught red-handed. So they knew why he has been elected. In this case also, this person has been fled away from Assam to Bangalore by after after committing a murder. He fled away, and he was caught from Bangalore, Lordship. So Lordship, this person, they knew why he has been arrested, but in some PMLA cases or in some UAPA cases, Lordship, some persons do not know. Even if anything case against me or Michael or any other person also, we do not know whether if there is any cases are there. So sometimes people are caught at any time. So they should know why he has been arrested. That is the aspect, Lordship. So Lordship, after Bihan Kumar and Bihan Kumar's judgment, everything is settled. It comes the dispute came, Lordship. Bihan Kumar judgment never says whether it is prospective or retrospective. And as a common knowledge and a common law, Lordship, that when it is not mentioned whether it is prospective or retrospective, it will be retrospective. So when it is retrospective, then then it will hit the judgment of Pankaj Bansal, R.K. Arora, and all are the same constitution bench. All are the same judges bench, two judges bench, Lordship.
No, as per you, the Arora is clarified only.
Arora is clarified, Lordship. That is then Bihan Kumar cannot go to the effect of Lordship R.K. Arora, go beyond Arora, R.K. Arora. Then even as so we also cannot limit it. So that is why I am saying that Bihan Kumar's judgment has no retrospective effect. It will have the prospective effect, Lordship. And when there is one more argument I would like to face, thereafter, Lordship, one more judgment came, Lordship. That is, Lordship, Kasi Reddy, Upendra Reddy, Lordship. Though it is reportable, but it is not yet reported, Lordship. It is delivered on, Lordship.
That in fact helps the petitioners, Lordship.
Hmm?
That in fact helps the petitioner. It says that grounds of arrest has to be communicated like the charges are framed.
It is published on, Lordship, to May 23. It delivered on 23-25, Lordship. So, Lordship,
20,
kindly come to para 28.
when? When delivered? 20?
23 May 25. After Bihan Kumar, Lordship.
23 May.
Lordship. This judgment can, Lordship. So, Lordship, may kindly come to para 27 first. In para 27, Lordship, the object underlying the provisions of the ground of arrest should be communicated to the person arrested has been very succinctly explained in Bihan Kumar Sutra. On learning about the ground for arrest, the person concerned will be in a position to make an application before the appropriate court for bail or move the High Court for a writ of habeas corpus. Further, the information will enable the arrest person to prepare his defense in time for the purpose of his trial. For these reasons, it has been provided by the Constitution that the grounds for arrest must be communicated to the person arrested as soon as possible. Thereafter, para 28. For the purposes of clause 1 of Article 22, it is not necessary for the authorities to furnish full details of the offense. However, the information should be sufficient to enable the arrested person to understand why he has been arrested. The grounds to be communicated to the arrested person should be somewhat similar to the search framed by the court for the trial of a case. So, Lordship, what my learned friend has said, Lordship, it has to be like that, Lordship.
Further, my learned friend may read further. It has clarified.
29.
Yes, 29 and 30.
So my learned friend has stated, Lordship, that it has to be somewhat how the Lordship, we know how the charges are framed when they frame, Lordship. So in some questions put, Lordship. So, Lordship, in that case, Lordship, when arrested person should be somewhat similar to the charges framed by the court for the trial of a case. So when person is arrested, when one person is that is why I'm arguing, Lordship, that sometimes in some cases, Lordship, in UAP cases, in like that cases, Lordship, person do not know what he has been done. But in some cases, when he himself knows, when some person is carrying some NDPS substance with him, when person has got committed murder of another person, then he do not know. He has to be explained why the details. That is something different, Lordship. Then, Lordship, may kindly come to para 36, Lordship. If a person is arrested on a warrant, the grounds for reasons for the arrest is warrant itself. Lordship will see this. When a person is arrested on a warrant, the grounds for reason for the arrest is the warrant itself. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed the grounds for his arrest. If the warrant is read over him, then it is it will be treated as that he grounds has been informed to him. Then also we all knows, Lordship will not known is very well what is written in the warrant Lordship. It is a format. In every warrant, it is a format. Nowhere in a court, for every person, every warrant is written separately. No, it's a simple format. And wherein only the sections and case number is inserted. So if the warrant itself is reading before him is the ground of arrest is told, then why not this ground of arrest section 15 notice? If you say that we have given compliance, then why not the section 15 notice is sufficient? Section 15 notice is also sufficient. So Lordship, thereafter Lordship, I am coming. If the arrest without a warrant, he must be told why he has been arrested. If he is arrested for committing an offense, he must be told that he has committed a certain offense for which he would be placed on trial. In order to inform him that he has committed a certain offense, he must be told of the acts done by him which amounts to the offense. He must be informed of the precise acts done by him for which he would be tried. Informing him merely of the law applicable to such acts would not be enough. So, Lordship, what we have said, Lordship, that when we have arrested one person, he definitely everyone that because of this reason you have been arrested. Though he knows, even in this case, Lordship, in the CD also it is written, Lordship. Ground of arrest has been informed to him, Lordship. In the CD on that day, Lordship, it is written, Lordship. So, Lordship, thereafter, Lordship, these judgments came. So, Lordship, will find the contradiction of judgments, Lordship. There are so many contradictions of judgments. First, Pankaj Bansal, R.K. Arora, then Lordship, this Bihan Kumar, Pavir Purkasta, then Kasi Reddy. All these are contradicting in each other, Lordship. So, Lordship will find one more judgment. Lordship will find, Lordship, that Lordship, State of Maharashtra, AR 1966 reduced. AR 1960 is a Shobhadam. State of Maharashtra. Here also, Lordship will find in para 20, Lordship. This is a constitution based judgment, Lordship. It says, Lordship. Here, Lordship, para 20, Lordship. Article 22(1) is in two parts and it gives to persons arrested a twofold protection. The first is that an arrested person shall not be detained in custody without being told the ground of such an arrest. Specifically stated, Lordship, without being told to the ground of arrest. And the other is that he shall be entitled to consult and to be defended by a legal practitioner of his choice. So this is the two parts, Lordship, merely. Thereafter, Lordship, may kindly again come to para 22, Lordship. I consider that there is room for further deliberation on the point. I do not see how we can differentiate between arrest of different kinds.
No, where you have come now?
22.
Para 22.
Para 22.
Oh, yes. What is the
We
para?
consider that there is room.
You're reading line from? We consider. Para 22 starts as now I come this in my.
I consider that in the next page, Lordship. 2022. There are some other 22.
No, you're pressing on 22, na?
Okay.
Para 22.
22.
Para 22 starts with a different line here in our case.
Publisher is different.
Oh, that's why. You just mark it and then maybe get ইফালে ইফালে হয়ে যাবে।
I consider it. 21.1.
Acha. Oh, there in your copy it is 22.
Yes.
Oh, that's what.
I consider that there is room for further deliberation on the point. I do not see how we can differentiate between arrest of different kinds. Arrest is arrest, whatever the region. Insofar as the first part of Article 22(1) is concerned, it enacts a very simple safeguard for persons arrested. It merely says that an arrested person must be told the ground of his arrest. In other words, a person's personal liberty cannot be curtailed by arresting without informing him. So, as soon as is possible, why he is arrested, where the arrest is by warrant, the warrant itself must tell him. There, where it is by an officer, where it is by an officer, the order must tell him that, and where there is no warrant or order, the person making the arrest must give that information. However, the arrest is made, this must be done, and that is all that the first part of Article 22(1) lays down. I find nothing in Article 22(1) to limit the requirement to arrest of any particular kind. A warrant of court and an order of any authority must show on their face the reason for arrest. Where there is no such warrant or order, the person making the arrest must inform the person the reason of his arrest also. So this is indeed the lordship, it is stated lordship that he has to be told lordship. He inform and he told lordship. So lordship, my next point line of argument will be lordship when there are some contradictions as lordship regarding the main basis of the judgment lordship. That because lordship in this case lordship when Pankaj Bansal came, it stated lordship that it is henceforth R.K. Arora more clarified it lordship that prior to Pankaj Bansal it is not fatal also even not faulted with lordship. So lordship after Pravir Burkhardt also took the ratio from Pankaj Bansal. Even Bihan Kumar also took the ratio from the Pankaj Bansal, but ignored that part, that lordship whether it will be prospective effect or retrospective effect. Because if you consider a Bihan Kumar case, if it is go by the, we cannot even one thing lordship we have to say lordship, we cannot limit one retrospective effect to one limit. If it is a retrospective effect, it will go to 1960 also or 1950 also lordship. Because we cannot limit it to the R.K. Arora lordship. So lordship when one judgment says that and one judgment says another, that is why in the cases lordship I am going to submit lordship that is Sandeep Kumar Bafna lordship. When one judgment, subsequent judgment will be the par inferior judgment lordship. Lordship may kindly come to para 19 of the judgment lordship. Okay. Why it is lack of care lordship? It cannot, lordship got it. It cannot be overemphasized that the discipline demanded by a precedent or a disqualification or a diminution of a decision on the application of the par incuriam rule is of great importance, since without it, certainty of law, consistency of ruling, and committee of courts would become a costly casualty. A decision or judgment can be par incuriam, any provision in a statute, rule, or regulation which was not brought to the notice of the court. A decision or judgment can also be par incuriam if it is not possible to reconcile its ratio with that of a previously pronounced judgment of a co-equal or larger bench. So this applies with his lordship. Because the ratio of Pankaj Bansal is prospective, and now this his ratio he has in this case lordship it is retrospective. So it is difficult.
Nowhere it is stated it is a retrospective, but
Because of that ruling that common law that as it is not mentioned in the retrospective, that is perspective, it's everyone and that is only on the basis of that lordship all the bail has been granted nowadays lordship. ratio that is previously pronounced judgment of a co-equal or larger bench, or if the decision of a high court is not in consonance with the views of this court, it must immediately be clarified that the par incurium rule is strictly and correctly applicable to the ratio decidendi and not to the obiter dicta. It is often encountered of high courts that two or more mutually irreconcilable decisions of the Supreme Court are cited at the bar. We think that the inviolable recourse is to apply the earliest view, as the succeeding ones would fall in the category of par incurium. Also, subsequent will come in par incurium. Thereafter, Lordship will make Lordship one more Lordship. The para 20 and Lordship, the whole paragraph, I think I need not to read Lordship. Para 20, next page, Lordship. Got it, Lordship. In the present case, Lordship, from by skipping 3-4 lines, 5 lines, Lordship. In the present case, Lordship, what Lordship?
In para 20, you were saying?
The para 20, next page.
Next page.
Para 20, next page.
Acha, para 20, next page. Yes. From?
Lordship, by skipping 3-4 lines from top, Lordship.
Mm.
In the present case, Lordship, what is
Just a second. Yes.
in the present case, in the impugned order, the learned single judge appears to have blindly followed the incorrect and certainly misleading editorial note in the Supreme Court cases without taking the trouble of concisely apprising himself to the context in which Rasmi Rekha appears to hold the Niranjan Singh par incurium, and equally importantly, to which previous judgment and earlier, it is important also, an earlier judgment cannot possibly be seen as par incurium, a later judgment as a letter, as the latter, if numerically stronger, only then it would overrule the former, Lordship. What does mean, Lordship? If the latter one is numerically stronger, subsequently, suppose one judgment came, and subsequently, what I understand from this judgment, Lordship, there's one judgment came, it has taken as the ratio, but it has been taken, but subsequently 1, 2, 3 more judgment came, but it is the decision is something different from the earlier one, but all these 3/4 are same. Then, if it is because the subsequent is the numerically stronger, that is why it is not then that is why the first one may not be, subsequent one may not be the par incurium if it is numerically strong. But in our case, the earlier one is numerically stronger because Lordship, that is that I have shown Lordship 1961, 66 judgment. Pankaj Bansal, R.K. Arora, Prabir Purkar also says it is henceforth, Pankaj Bansal henceforth is confirmed. Thereafter, Lordship, in Kasireti also came, Lordship. So 5-6 judgments came, Lordship, which stated that Lordship it will have the prospective effect, Lordship. So, Lordship, this as the Lordship has come. Thereafter, Lordship will find, Lordship, the Constitution Bench Judgment 1, Lordship, there, Lordship. National Insurance Company versus Pranay Sethi, Lordship. See the 5 judges. What is it? Wait a second. Here, Lordship will find in para 16 to 23.
Pranay Sethi.
Pranay Sethi, Lordship, National Insurance Company.
Every second is recent.
Pranay Sethi is of, I mean, MSCT matters or what?
Regarding MSc methods, but here it is also stated about when it will be par incurium. When
Okay, good.
there are two judgments
That part is
captured,
discussed.
that is on the same point also. Also, Meghali cited the National Insurance Company into the
You took take the note now already? Yes. We will take out.
para 16 to 23. Here the Sandeep Kumar Apna case has also been discussed, Lordship. And in each and every case, Lordship, it is discussed, Lordship, and held, Lordship, that Lordship, subsequent judgment, if the same constitution when same judges, Lordship, subsequent judgment will be par incurium, Lordship. Yeah. This is a 5 judges bench, Lordship. So, Lordship, here in all the Lordship, in all aspect, Lordship, one more judgment it will handle whether synthetic chemicals is in Lordship, one more judgment, Lordship, I have given the citation, Lordship, here in since in synthetic chemicals lordship case lordship. Here also lordship,
Just
the sub-silent part.
citation.
The sub-silent part is discussed lordship. When there is sub-silent, then it will be, that part will be the par NPM, it will be treated as a par NPM lordship. So lordship, here it is stated lordship that when may I read or one line lordship, in any case of bench did not examine it nor did it base its conclusion on it. In absence of any discussion or any argument, the order was founded on a mistake of fact, and therefore it could not be held to be law declared. The bench further was not apprised the earlier constitution bench decision in Hoist Chemicals versus State of Bihar and Ganga Sugar Mill versus State of UP, which specifically dealt with the legislative competence of levying sales tax in respect of any industry which had been declared to be the public importance. Therefore, the conclusion of law by the Constitution bench that no sales or purchase tax could be levied on industrial alcohol with utmost respect failed in both exceptions, namely rule of sub-silent and being in par NPM. It is the lordship that lordship, when one part is silent, Pankaj Bansal ratio has been taken, Prabir Purkar ratio has been taken, but the part whether it is when there is a specific mention, the ratio paragraph is 35. When it is specifically mentioned that it is henceforth, that part is not mentioned in Bihan Kumar's judgment. So that part, regarding that part, that whether it be prospective or retrospective, that part will be the par NPM. So that regarding that part, it will know the precedence lordship. It will not be treated as a precedent lordship. So sub-silent part, for the purpose of sub-silent, when there is sub-silent part, so that part will be treated as a par NPM lordship. So this is the judgment. So lordship, in all these judgments, lordship will find one important thing is that lordship, when one judgment says all the judgment says lordship prior to the arrest of Pankaj Bansal lordship. Pankaj Bansal, it is there is no requirement of giving ground of arrest in written. So when we have furnished that ground of arrest in a format, that can be accepted as a ground of arrest. Otherwise, lordship, it will be against the judgment of the Pankaj Bansal Arora lordship. So lordship, my humble submission before lordship that lordship, when all the judgment says and most of the judgment is in favor of not giving the judgment ground of arrest in writing prior to Pankaj Bansal case lordship, and he has also already been arrested prior to Pankaj Bansal case lordship.
Okay, Mr. Ahmed, you have annexed the earlier rejection order also. In which page? 90?
That your lordship will find page 91
Ah.
and
Regarding
93.
lordship, regarding the part of
Two orders.
Two orders.
Lordship.
One is on 94, na?
Yeah,
94, 95.
yes, 93 to 96 I have given. lordship.
Yes.
Well, regarding that part, lordship, he was not produced before the judicial magistrate lordship within 24 hours lordship. That I had flag mark it lordship. He was arrested in Bangalore lordship. Thereafter, on the when he was arrested, he was a petition has been filed before the court at Bangalore lordship for giving transit remand for transit remand, and after obtaining that remand lordship, their police came to Guwahati, and thereafter he has been produced before. Immediately after reaching here, he has been produced before the judicial magistrate lordship. So that part that has been complied with lordship. As he could not produce before the end also. Regarding merit part, lordship, there is lordship.
Regarding merit part, my lord, just I want to point out, if your lordship sees, my lord, there are certain other cases, my lord, is BA 970/25 is there, my lord. So rejection,
Other cases mean
other, my lord, your lordship's rejected cases.
for his petition only.
Yes, my lord, yes.
This petitioner.
Yes, for this petition. No, my lord, for other co-accused,
Oh,
I-
other
Like,
co-accused person.
there
Okay.
your lordship has very, my lord, it has been, my lord, observed, my lord, and in the rejection order also, your lordship will find the materials against the petitioner, what is there, my lordship may kindly peruse that 970/25, that order is there. No, গোটেইকেইটা মই কৰিম। Your lordship will find the materials, that part regarding the merit part regarding.
Hmm.
Out of 10 witnesses examined, my lord, their lordship has already
Ah.
observed, my lord, regarding the
So it
merit.
was a murder, na, by
Murder by making a conspiracy by 3 persons, my lord. Murder and looting, my lord. 395, my lord.
395
395 and
also,
302.
they were somehow arrested, I think.
They were
yeah.
somehow arrested. So regarding gravity of the offense also demands, my lord, that they may not be released at this stage, my lord.
One thing we have to see, Lordship, that Lordship, Article 22(1) is not for releasing the accused person on bail, Lordship. It is for the Lordship, it is to give him a protection, give him information so that he can avail one counsel to defend himself, Lordship. It is not for giving the nowadays, Lordship, it has been shown in like way that Lordship, as Article 22(1) is there, Lordship, he has to be given on bail, Lordship. But Lordship, that mandate, we have that the very purpose of that article, mandate of that article, we have to see, Lordship. That when it is stated, Lordship,
I
he
can
has to
reply
be
to-
informed only,
I
Lordship.
can reply his argument for the whole day, Lordship, and already I have done this before another court. Already these issues were raised, already these issues were addressed. They have accepted that order. They have not challenged before the higher court. They have accepted that order. And now again, those submissions are made before this court. I have just placed before that, before this court, that order regarding that retrospective, prospective. All these things already I have made argument. I am not repeating those submissions, Lordship. And probably your Lordship also passed one order that I could not recollect regarding this sub-silence or other parts also. And he has relied on Constitution bench of 1966, but the Probir Prokasta judgment your Lordship will find, after discussing Ramkishore Arora, it was taken into consideration. And taking into consideration, Hare Krishna was relied, which was passed in the year 1962 by Constitution bench, 5 judges bench. That was relied. And another judgment of Honorable Apex Court is also there regarding judgments will be always retrospective, sorry. The judgment cannot be made prospective. So even if we take that Pankaj Bansal was made prospective, the other judgments will remain also Bihan Kumar and Probir Prokasta. All those are elaborately discussed in the said order also. So I am not repeating all those submissions. And one thing my learned friend has said that warrant of arrest and grounds of arrest that will be same. That will probably be absurd submission because the warrant is issued by a court after going through the records and all the details are mentioned there. And this is the just format which was given by the investigating officer. If we take his submission to be true, then 161 statement and depositions are same. That is what I have understood. that cannot be, Lordship. And already your Lordship also earlier discussed, so I am not repeating all those things.
So regarding also retrospective judgment and retrospective and prospective judgment, that there I will be very clear. So, Lordship, yes, Lordship, I also admit, Lordship, every judgment, if it is not mentioned, whether it is retrospective or a prospective, every judgment is a retrospective. But when there is a conflicting of judgments, when there is a conflicting of judgment, that is why that is the Sandeep Kumar Apna come. That is why, Lordship, this Pranay Sethi came, Lordship. That when there is a conflicting of judgment of the same constitution bench, then, Lordship, which one will be applicable? Why, Lordship, then, Lordship, why today? Why we are not going by the order of the R.K. Arora, Lordship? Why we are not going by the Pankaj Bansal judgment, Lordship? Only the Bihan Kumar, wherein only that too only so that the accused persons are getting the relief, Lordship. So that is when there is a conflicting of judgments on the same issue, then it will be treated when which one will be applicable. That is mentioned in the Pranay Sethi judgments, constitution bench judgments, and that is why that is in there also. Lordship, Sandeep Kumar Apna is also mentioned, Lordship. So, Lordship, I am everyone knows it is. I also admit it has a retrospective effect. But when they applicable, it will be applicable when there will be no conflicting of judgments to that effect again, Lordship. When there will be a conflicting judgment, anyone can be Even there is one more judgment came, Lordship, as I have not gone through the entire, it is a 2025 judgment, Lordship. This year, Lordship. When it is stated, Lordship, then if it is there is sometimes as the applicability of judgments order cannot, there is some difficulties can. Then also, then also it will be treated as a parent PM, Lordship.
I have not found a single judgment which says that Ramkishore Arora, Pankaj Bansal, Prabir Purkasta or Bihan Kumar are in conflict. Even in fact, the my learned friend has relied on that Reddy judgment, which was given to your lordship, which was passed on 23rd May. That also relied on Bihan Kumar. I have not found anything is conflicting. There is no conflict among these judgments, lordship.
Conflict, Lordship, because
Only-
RK says it is not faulted
If
with
he is
priority
said
that
that it is
Lordship,
conflict, go
then
go
Bihan Kumar, why
clarify.
Bihan Kumar came says Lordship that
That is not done.
it has to be, then that is the conflict, Lordship. RK definitely particularly says if arrest is prior to Pankaj Bansal, then it is not a
Even
faulted. Lordship.
Ramkishore
Then-
Arora says that it has to be informed within 24 hours. He is
Yeah.
relying on Ramkishore Arora. Ramkishore Arora paragraph 37 itself says that
that
you
is-
have to inform. Where you have informed? Where at the ground? Mere mentioning of section will not do. That is the whole case. Even if we accept the Ramkishore Arora, then also it goes in my favor. You have to inform within 24 hours the grounds of arrest. How you have informed that these
That
are
is,
the
Lordship,
sections.
that is the
These are
main
the
interest of
grounds.
whether it is requirement of written ground of arrest is required or not, Lordship.
No, even already
That is
also you
there.
have not informed. You have said that I have issued the notice under section 50 and 47.
That
So
notice
those
also there,
notices are
Lordship.
before your
On
lordship.
that day,
Lordship
note,
has seen
Lordship, prior to 2023 notice there, Lordship, Lordship, find it, Lordship. That,
Obliged,
that has
Lordship.
been informed him, Lordship. So, Lordship,
One, you want to say something? You are on one.
Yes.
Because I don't want to hear, that's why I'll fix a date only.
Yes, Lordship. My case is covered by his argument. My arrest is 28 2024. So that is after, firstly.
after
Se-
COVID Lordship, Lordship,
Secondly, it is not a law that if a arrest is found illegal, then
if he is arguing on that one, then again, I will step.
consequentially we have to be released. Bihan Kumar at para 14 specifically said that we cannot be kept for 1 second also. That is the language.
Okay.
If it is found violative of Article 21 and 22,
Okay.
then we
One more matter was there, it will be left over.
One judgment regarding the victim's right to be protected.
So I am covered by his.
Okay.
One matter.
Your one matter was there, it will be left over.
Sorry.
Okay.